Miles. And Ms. Miles was previously in court, entered a plea of guilty in cause number 24 at DCCR 2330 to tampering with physical evidence. I've received the pre-sentence report. Has everyone had an opportunity to review the report? Are there any additions or corrections?
No, none are good.
In addition to this pre-sentence report, I've also received and reviewed a number of jail incident reports. Has everyone had an opportunity to review those? And you're 19? Why haven't you been acting right in jail?
Most of the reports are not true. One time I did not uncover my face on video. I did, because I was asleep and she didn't wake me up. Ms. Bella didn't wake me up. When I got here in June.
So she's lying when she says she tried a few times and then she taps you, taps your bed, kicks your bed a little bit.
That day Ms. Bella never tapped me. And then in June, I got in a fight when I first got here. The girl swung at me first.
Okay.
That's accurate what it says, the girl here with the closed fist.
Yeah, I mean, if you get hit first, that's not the one that I'm so worried about. It's the... eating at your bunk when you're not, I mean, it's not even big stuff. It's just not following the rules. And if you can't follow the rules in jail, why should I believe that you can follow the rules on probation? When you're in jail, when you're on probation, when you've committed a felony, you don't get to make certain decisions for yourself anymore, right? Now, you're not going to be like every other 19-year-old and get to just do what you want when you want. You're going to have to do what either jail says or what I say or anything like that. If I'm going to follow this agreement based on the nature of the offense and based on the age and all of this, we're going to get you some help up front to be making better decisions. Otherwise, I'm not going to follow the agreement. Things could be a whole lot worse. Do you understand? So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, and I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program. You're not going to get out of jail today. You're going to go to ISF instead, and you're going to hopefully pay attention and learn how to make better decisions. You're still young, you're still immature, but you're going to have to make some very mature decisions if you don't want to go to prison, and that's going to be to help you make those better decisions. Now, here's the thing. If you're in our jail and you start before they send you in the next week or two, or if you're in ISF and you are acting up and not following rules, putting something on your head that you're not supposed to, eating where you're not supposed to or when you're not supposed to, talking about whatever it is, I don't care, then you could be revoked just for not following the instructions. And you'll never get out and even have an attempt at probation. Do you understand? So whatever's going on and whoever your buddies are in there, you need to tell them, just sit there, do everything you're supposed to do. All the playing around's done because you want to get out and make something of your life. And if they don't want to, that's going to be on them. If you keep doing all this, you're going to have a felony conviction and you're going to go to prison. It's that simple. You understand? The part of this probation that is so good is that you don't have a conviction right now. And if you're successful and you complete your probation, you are never going to be a convicted felon. So this is a great opportunity. But if you do violate in any way, you'll be back in here, you'll be a convicted felon, and you could go to prison anywhere in that range of punishment, which is between 2 and 10 years. All right? I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you. You can go back with the bailiff. Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and We reset it for sentencing, just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I assume the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened, and hopefully not engaged in the type of conduct that caused this to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was, or her. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So obviously, if the court repeats 5, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address it as well. Is that right? What do you have to say for yourself?
I do apologize for the situation that went on, and I wish that anybody that was involved in the case would see that I'm really serious, and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full age.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report, where you were put in the parish jail, and then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies, that ended up with you going to prison. 5 years it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
The wrong case number.
I did.
You went on the robbery, and we actually entered the plea on the assault.
Sorry. 25 DCCR 0979
Right, assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I'll just say on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated.
Okay.
All right. And we have to have that discovery certification today because the case is going to get to close
Not
down.
again, you never gave it to
Well, I mean, when she first pled.
So do I?
You didn't give
me. You
it.
to give me
Still
a,
got the credit for me being in here on this.
Yes. All the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you. Good morning. Are you Latrick Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because you know, on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it. And all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous, okay? All right, go back with the bailiff. I'll reset the case. Good morning. Is it Darius? Is it Valier or Valier? Villier. Oh, okay. And will your client waive the formal reading of the motion?
He does.
Mr. Villier, in cause number 17-27164, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 26th of 2017 for the offense of engaging in organized criminal activity, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violate, and obviously the years don't look like they match up, but this was filed back in, the motion was filed in 2022, so that would toll the time. All right, so it alleges you violated your probation. Count 1 alleges that you failed to report as directed to the probation department December 28th of 2021 and January 19th of 2022. And how, is that true or not true? True or not true?
Yes, ma'am.
Listen to the question. Thank you. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you provided urine sample October 29th, November 1st, November 3rd, November 5th, November 8th, November 10th, November 12th, November 15th, November 17th, November 19th, November 22nd, November
Judge, we can-
24th, December 1st, December 3rd, and December 6th of 2021 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Judge, in light of our agreement, we can drop the remaining counts if it's all right with the court.
That's what we've got here. No new offenses.
No, Judge, he, after all those positives, he was ordered to go to
ISO.
ISF, and he never did. And his explanation for his absconding that I was given by probation was that he moved in with his girlfriend and tried to ignore it, I guess.
Okay.
So that's why we're here today.
All right. Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Valier is not competent?
No objection.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of engaging in organized criminal activity. Sentence you in accordance with your agreement to a term of 10 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you all.